The DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-LAW, or you can interact with the show by sending an email to ask@DeWittLaw.com or by calling 407-53-MOSES. Every Sunday morning here at 10 a.m., you'll learn how Florida's legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo's going to answer your questions to discuss the latest legal issues affecting the citizens of Central Florida. You can also check them out, DeWittLaw.com. And again, we got a stack of questions to get to again this morning. If you want to get your question in, just send it to ask@DeWittLaw.com. Good morning, Mo.
Good morning, Jay. How are you?
I'm fantastic. I did see that we had a verdict on that whole Murdoch trial, huh?
We did, yeah. I mean, in a quick verdict, too. I'm sure everybody out there has heard a lot about it by now, so I won't belabor it too much. But, yeah, I mean, the jury said that they deliberated for about 45 minutes after a 6-week trial and came back with a guilty verdict, obviously.
As a prosecutor or a defender, is that bad for which one? Like, if somebody comes back that fast, does the defense go, uh-oh, or does the prosecution go, uh-oh?
So usually the defense is worried with something that quickly.
Okay.
However, if you remember the O.J. Simpson case, they came back, I think, within a few hours, and it was a not guilty.
Right.
So, I always say you never really know. It always kind of depends on the facts of the case. But here, obviously, that wasn't the case. It was a guilty verdict. It's been interesting listening to some of these juror interviews since the case. I think 3 of the jurors have given interviews, one of which was the juror who was asleep for most of the trial.
What did that juror have to answer? I don't know. I don't remember.
She didn't say a whole lot. But, there's going to be a number of issues on appeal here. And, whether it'll get overturned or not, I mean, that's a different story. I think it's probably going to be hard to get this case overturned, even though there definitely were some legal errors.
Right.
I don't know if there are large enough legal errors to get the case overturned. And certainly, appellate judges are going to be very cautious to overturn a case like this, where it was a 6-week trial, highly, publicized, probably the largest case, publicly televised case in South Carolina history.
Right. Yeah.
But there definitely were some legal errors made there. One of which was kind of this one was actually kind of brilliant on the part of the prosecution. We talked about before in this case the motive didn't really make sense, right? The motive was basically that somebody in his law firm, in Alec Murdaugh's law firm, approached him and said, "Hey, I think there's money missing here," and that was the same day he shot and killed his wife and son.
Mm-hmm.
So they were basically saying, oh, he was approached, he knew things were crashing down, so he went and murdered his family. To me, doesn't really add up. That's not really a logical motive.
Right.
But the reason they did that was because they wanted to bring in all the character evidence of all his crimes, all his financial crimes. And so typically in a case, in a jury case or a criminal case like this, you can't bring in prior bad acts unless they meet certain criteria. And usually that criteria is you have to be convicted of a felony or convicted of a crime of dishonesty. Well, here, even though he admitted to the crimes on the stand because he had to, essentially, he hadn't been convicted yet.
Right.
So under what we call 403B, which is character evidence, all of that should have been inadmissible, should not have been allowed in court. The only way it could be allowed in court is if it was motive. And so that's why they basically used this motive as character assassination.
That's super smart.
It's very smart it's very cunning on the part of the prosecution. Right. But the question is going to be, I think, for the appellate court is, should the judge have allowed it to be opened up that much? If the motive, in my opinion, if the motive was simply he was confronted on this day about one instance or a couple instances of money being missing, should the testimony have been limited to what happened on that day?
And not his entire shady past of
right.
things.
I mean, because what the judge allowed was, if you watch the trial, basically going back through, some horrific crimes that he committed where, he stole money from paraplegics and, you sat down at the table with them and looked them in the eye and stole their money and convinced them, just like you're convincing this jury here today. Wow. And really used it as character assassination. So whether the judge should have limited that more or not will ultimately be determined by the appellate court on appeal. But yeah, it was a very smart move by the prosecution. Now, the other issue on appeal, which I think was actually a very dumb move by the prosecution, was that they repeatedly asked him, after you had been arrested, you never came forward to the police and brought this evidence or corrected the testimony that you were at the kennels
right
after you were arrested, which is directly commenting on his Fifth Amendment right to remain silent. So especially post-arrest.
Mm-hmm.
If it was pre-arrest, that may not have been as big of an issue. But post-arrest, you cannot comment on someone's right to remain silent. And they repeatedly did it over and over again. They didn't need to do it. And frankly, I think they gave the defense a stronger avenue for appeal by doing it.
Right.
Again, I don't know that it'll actually lead to it being overturned, but it's an avenue that is now open because they commented on that so much. Completely unnecessary, in my opinion. Prosecution really shouldn't have done it, but I'm sure they were throwing everything that they could and that they could get away with to try to get the conviction, which obviously worked here.
What an absolutely crazy trial. I mean, this whole thing is just insane.
Yeah, I mean, I've been fascinated by it. And the one thing that came out after the trial that was absolutely crazy, in my opinion, was that one of the jurors, and it's the main juror who's kind of going around speaking to the media. Like I said before, there's really been 3 who have kind of given interviews, but there's one who's given a ton of interviews, who has a lot to say about it.
Book deal.
Maybe he's working that book deal. He's working something, and he's young. He's like 25 years old or something.
Right.
He was actually about the same age as Paul when Paul was murdered. But he's been speaking to all the media, and what's crazy about that is this juror is the brother of a police officer who testified in the trial. I think he was the first or second witness who testified.
Really?
Yeah. And that was disclosed by the juror, and they didn't boot him off the jury.
How does that get by?
Well, you typically during voir dire, you kind of ask jurors, can you be impartial, things like that. I guess in South Carolina, they can't individually interview the jurors or the potential jurors, so it makes it a little more difficult. But this was disclosed, and the defense didn't strike him. I don't know if they moved to strike him for cause or not, because that part of the proceedings were not broadcast.
Right.
But if they didn't, that could be some post-conviction relief, ineffective assistance of counsel. But we talk about sometimes cases are won or lost at jury selection, and I think this is one of those cases. I think they lost the case the second they put that guy on the jury, with his brother being a police officer who was at the scene, and he said, his brother didn't really speak to him about the case. But first of all, as defense counsel in a case like this, you have a hurdle to. Anytime a police officer gets on the stand, right? They have they're kind of cloaked with credibility just based on the job and the position they have.
Sure.
And one of the big theories in this case was that the police messed everything up. That SLED, South Carolina Law Enforcement Division, did a terrible job. The police did a terrible job investigating it. That they just the forensic were awful. So now you're attacking the credibility of the police, which is difficult enough. But when one of your jurors is a brother of the police officer, I mean, he grew up with this guy. I mean,
right.
You can never break down that person's credibility. And of course, I'm sure he thinks highly of his brother. He's probably going to think highly of all law enforcement. So, I mean, I think they really lost this case the second they put that guy on the jury. And the fact that he's going out and speaking to the media, to me at least, says that, he's really not only has a vested interest, but he was probably very vocal in that jury room, getting people convinced to kind of take his side.
I'm sure,
Because when they went back there initially, he said that they had 2 people who said not guilty, 1 person who said unsure, and the rest said guilty. So, if I had to guess, and again, of course, this is just pure speculation, but given that he's been so vocal in the media, I'm sure he was the one going through it and saying, all right, this is why you need to switch your vote to guilty, so on and so forth. This is what the evidence shows, yada, yada.
Can his brother talk to him at any point, like during that, or jurors have to remain?
You're not supposed to, as a juror in this case, you were not supposed to speak to anybody, especially a witness, but anybody about the case during the course of this case. And now, here they were not sequestered. So the judge decided not to sequester them, which, to be away from your family for 6 weeks, being sequestered in a hotel room, not only is it expensive for the county, but that's a big toll on your life as well. Yeah. In the case like the O.J. Simpson case, they were sequestered. So here they were not sequestered, but they were asked not to speak to anyone about the case at all.
Right.
And we saw that one juror got removed because they made some sort of comment outside the courtroom about the case. And the defense was very upset because apparently, at least rumors are that the the juror's comment was that the prosecution has not proven their case.
Right.
So, given the verdict here, obviously they're a little upset about that. But you're not supposed to speak about the case. And I don't think they disclosed the judge certainly didn't disclose what the conversation was, but they knew about it. But yeah, you're not supposed to speak to anybody about the case, including the other jurors, until you go back for deliberation.
Interesting. And I mean, granted, this is just me guessing, but how do you not talk to your brother for 6 weeks, and you want to defend your brother's honor and law enforcement, everything like that. Yeah, how they let that guy end up being, of all the people in South Carolina that they could have put on the jury, they pick a brother of somebody that's testifying.
Well, and obviously there was a ton of media attention around this case. I'm sure if you remember the Casey Anthony case when it was here in Orlando, every media outlet in the country swarmed the Orange County courthouse.
Yeah.
And I'm sure it was the same thing here, but with a courthouse that was probably 1/20th of the size.
Right.
In a town that was much, much smaller, that I don't even know if they had enough hotel rooms to accommodate all these people, frankly. I mean, this is low country South Carolina. And, it's an area where really everybody kind of knows everybody. So, I'm sure the people in the town knew who was on the jury.
Right.
Now hopefully they respected that and didn't speak with them during the case. But, people were saying, that's why Alec Murdaugh's law firm did so well in this area, was everybody knew them. So when they had a jury trial, the jury just agreed with them. So you bring in some, insurance defense lawyer, because they did personal injury mostly.
Right.
You bring in some insurance defense lawyer from out of town. Well, they're gonna side with the hometown lawyer every time. That's just the kind of area this was.
Right.
So
everybody
show up. Oh, that's Alec. Whatever he's saying must be good.
Right.
And so that's one of the reasons they had such success in this area. There's a few other reasons as well, but that's just the kind of area, the kind of place that this is. So, to have a juror whose brother is a witness in the case. I mean, it's hard enough when you have a juror whose family member is in law enforcement, and that's something that we typically probe about, especially if it's a criminal case. Hey, you got a family member in law enforcement. Are you going to be able to be impartial here? Are you going to give a law enforcement officer's testimony any more credibility than a lay person, than a regular witness, things like that? When it's a family member, sometimes you have concerns there. When the family member is a witness in the actual case and you're expecting the juror to be impartial to their brother's testimony,
right,
and weigh it impartially, and if they attack his credibility, you're going to be able to believe that his credibility is flawed in some way. I think they lost the case the second they put him on that jury. And it's amazing it didn't come out till the end, obviously, because the jurors can't speak.
Right.
And that part of the jury selection wasn't broadcast, but pretty interesting turn of events. And it's also interesting, that he's the main one out there in the media too. I think that says
doing all
a lot.
that talking. Yeah.
Yeah. I mean, we haven't heard, at least, I haven't seen any of the other jurors besides those three speak so far. It'll be interesting to see if any of the other ones come out or not. Some people, don't want to be in the public eye,
right?
Especially kind of given what's gone on with this family. Maybe there's some, they were a very powerful family. Some people might fear retribution of some kind, or just backlash from the community. So they may want to remain anonymous for the, till the end of time.
Can you make me a promise that when this does come out on the big screen, we can go see it together in IMAX and you buy the popcorn?
Absolutely. I mean, there's already a Netflix special, an HBO documentary on it.
My family's already watched it. They're like, you haven't seen it yet? I'm like, I've seen a little bit here and there, but like, it's so good. So
it's a story that I don't think Hollywood could write.
Right.
Let me put it that way.
Yep.
So.
No, they wrote the script for him. So, all right. Well, we're going to get to your questions here coming up in just a moment. If you've got a question, you can email it to us, ask@DeWittLaw.com. But if you need any legal advice and maybe you don't want to do it here on the radio, you can call the office anytime, 1-800-DeWitt-Law. That's 1-800-DeWitt-Law. Or you can also go to DeWittLaw.com. We will be back coming up in just a minute with some questions and some advice. You're listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm, taking your questions and giving you some legal advice. You can get your question in at ask@dewittlaw.com. You can also call and leave a voicemail if that's easier, and then we'll play your call over the air and get you some advice. 407-53-MOSES. You can also check them out online for all your legal advice, DeWittLaw.com. All right, Mo, you ready to get some questions and give out some advice?
Let's do it.
Here we go. Let's start off with this one. Mo, I work for a tree company. When I started, we signed a contract where I get paid $23 an hour. Now they did a quote-unquote evaluation, which most of us got 4 out of 5 stars, I guess it is. And a new manager came in and wants to lower everyone's pay. Now I'm going to get paid $20 an hour. Is that legal? Since I signed a contract stating how much I was going to get paid, he said, well, I'll get a new paper for me to sign where it states how much they're going to pay me now. Can they do that? Obviously, they will say either sign or find another job.
So, I mean, Florida is an employment at will state, basically meaning they can terminate you for any reason as long as it's not discriminatory. Now, the one exception to that is if you have an employment contract, so you need to look at the terms of the contract. But I'm guessing with a contract like this, it's probably more of just an offer letter saying, hey, this is what you're going to get paid, this is your position, something like that. There's probably no term, meaning that they are guaranteeing you a certain rate of pay for a certain period of time.
Okay.
So, in those situations, they can come to you at any time and say, hey, we got to lower your pay, and you can either accept it or you can go elsewhere. I mean, actually, I had a buddy during the Great Recession who worked in real estate, and I won't say the exact position or job,
right?
But I think during the recession, they came to him 4 times and basically were like, you can either accept the lower pay or you can go elsewhere. And, of course, there were no other jobs, so he didn't really have a choice but to reduce his pay rate. But as long as they're not doing it retroactively, there's really not a whole lot you can do about it. It's just freedom of choice, essentially.
Okay, so once he's worked those hours at $23 an hour, they got to pay you at that. But once they put you on notice or whatever and you signed for 20 now,
if they retroactively try to do it without notice, that's where they can get into some trouble there. But if they're basically saying, hey, we got to cut your pay going forward, you can either take it or leave it, then they're, again, we're an employment at will state, so that's just freedom of choice, and they can certainly do that as the employer, as long as it's not based on anything discriminatory, right? So, even though we're an employment at will state, you still can't discriminate based on, anything that's a protected class, age, sex, gender, things like that. So as long as they're not doing anything that's discriminatory, then they can basically say, hey, we're going to pay you whatever we want to pay you, and you're free to accept it. You're free to go elsewhere.
All right. Hopefully that helps.
So,
all right, got a couple minutes here. Let's see if we can get to this one. I got cited for speeding 10 miles an hour.
Slow down.
I got cited for speeding 10 miles an hour over the speed limit and having no insurance at the time. What would the outcome be, and do I need to hire an attorney for something like this?
Well, first of all, slow down.
Yes.
Get insurance.
I thought you were talking about me reading the question. I was like, was I going that fast? No. Stop speeding.
Stop speeding. Look, depending on your driving record, sometimes it can be beneficial in these situations to have an attorney present. Sometimes they can get it where you don't get points on your license. Maybe you have to pay the fine. And typically those attorneys are fairly inexpensive, the traffic ticket attorneys. As far as, the punishment for those, well, a speeding ticket, as we all kind of know, is typically some points on your license and a fine. Failure to have insurance, they may be able to suspend your driver's license on that one if you don't get insurance. Again, this isn't my area of expertise by any means, but you want to look into that one.
You're not getting locked up.
Yeah, I would at least call a traffic ticket attorney, have a consultation with them. I'm sure a lot of them do it for free. And then if you want to hire them, you can certainly do that for, like I said, fairly inexpensively. So it might be worth in your situation. Now, I have seen, because back in my early days, I covered traffic court for a buddy of mine one time.
Right.
And, if you have a horrendous driving record, typically the judge will not give you much leniency.
Cut you a break.
Yeah. So, they have your driving record in front of them there when you're, challenging the ticket. And if you have, if this is your 30th speeding citation, they're not going to be real happy with you.
Right. Let's hold on and deal with these 2 DUIs first, and then we'll get to the no insurance.
Right. So, my recommendation would be get insurance as quickly as possible if you can. Have it before you go to court if you're going to go to court. That way you can show the judge that's been brought up to date, and you're now in compliance, and maybe there was just a lapse because of payment issue, the bill went to the wrong place, whatever it may be. But it's been cured now. And then you can basically ask for some forgiveness on the speeding ticket, maybe, and maybe get those points waived. so you don't have to do the driving school. But that's
Perfect.
probably your best case scenario.
Good to know. All right. Hopefully that helps out with your advice. Again, keep sending those questions into ask@DeWittLaw.com. You can leave that voicemail, 407-53-MOSES. You can also call the office anytime if you need some legal advice, something you just got to ask and you want to know if Mo and his team can help you out. It's 1-800-DeWitt-LAW, 1-800-DeWitt-LAW. Somebody will be there to take your call and point you in the right direction. You can also find them online at DeWittLaw.com. We'll be back with the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
Congratulations on 305.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards, here every Sunday with Mo DeWitt of the DeWitt Law Firm, taking your questions and giving you some legal advice. You can send your questions to ask@DeWittLaw.com, ask@DeWittLaw.com. You can also call if it's easier and just leave a voicemail. Explain what's going on, what's your question, and Mo will give you some advice. That phone number is 407-53-MOSES, 407-53-MOSES. And also, don't forget, you can stop by, check out the website anytime, DeWittLaw.com, or call the office, 1-800-DeWittLaw.com. I know that's a lot of phone numbers right there, but the one thing that you can remember is you can always go to DeWittLaw.com if you need to get in touch with Mo or his team for some legal advice. All right, I'm going to throw one out at you, and this has got a little Springer-ish to it.
All right, let's do it.
But the question is, my cousin is dating a married man.
Okay.
What's the worst possible thing that can happen in all this so I can try and talk her out of this?
Well, I mean, from a legal perspective, there's not a whole lot there. Now, the married person, if they get divorced, the wife could come after the husband for dissipation of marital assets, and that's basically where you're spending money on an affair. You know, it's buying jewelry, taking trips, basically spending money on the paramour.
She wants that back. She can
they can pull that money back, essentially back into the marital estate. You know, things can go poorly, you know, from a life perspective.
Right, the non-legal point.
Yeah, the non-legal perspective there. But from a legal perspective, you know, even if you went down the route of adultery, which really, you know, obviously no states really enforce adultery laws anymore. Right. The adultery would be on the husband, not on the friend here, or the cousin. So yeah, it just messy. Just would be messy.
Legal wise, not
legal wise.
Much,
I mean, we see this about 20 times a day. Legal wise,
right?
But yeah, I mean, it can certainly be messy. It can certainly be ugly. You know, we've seen things, you know, escalate with domestic violence and things like that. That can obviously be very bad. But from, you know, a pure legal perspective, is the cousin doing anything illegal here? Not really. You know, ethically, there may be some issues, certainly. And, you know, from, like I said, it may be messy, but there's no, you know, legal ramifications, so to speak.
Gotcha. Okay. All right. Get your questions in. Ask@DeWittLaw.com. Speaking of divorce and that kind of thing, here's one. I've been divorced for a little over a year now. I'm currently paying my ex-wife alimony in the amount of $500 per month. She just recently got engaged to be married and moved in her fiance into her home. My question is, do I have to wait until they're married to request termination of alimony, or can I request it now since they're living together?
So most marital settlement agreements or divorce final judgments, alimony terminates upon remarriage. The only time it doesn't is if you agreed to not have it terminate, essentially.
Okay.
So the first place to look is at your marital settlement agreement or your final judgment of divorce. If it's a final judgment, then it definitely terminates because that's pursuant to statute. If you did a marital settlement agreement, then there is a possibility that you agreed not to terminate alimony upon remarriage, either by accident or deliberately. Now, alimony can also be modified based on cohabitation. And cohabitation is not just living together. We get a lot of people who call us and say, hey, my ex-wife's got a roommate, I want to terminate for cohabitation. That's not what it means.
Okay.
Cohabitation means you're basically in a financially supportive relationship just as if you're married. And so in this case, from the information we have, they're living together, they're engaged, they're basically a married couple, they just haven't gotten married yet. Assuming that their finances are somewhat mixed, you may have a basis to modify for cohabitation. Okay. Now, the thing here to remember, though, is it's automatic once they get remarried. So assuming they're going to get married soon, it may not be worth the money to bring a lawsuit to modify based on cohabitation.
Like if they're getting married in 4 months, you might as well just wait it out.
It's going to be $500 a month. That's $2,000. It may cost you $5,000 to bring a case for cohabitation.
Gotcha.
The numbers just don't work out there, essentially. Even though you may want it done faster, certainly.
Right.
Even if you file for cohabitation today and the judge terminates it as of today, you spent $5,000 instead of the $2,000.
Gotcha. Doesn't make sense.
Yeah, dollars and cents don't make sense there. So you basically you can modify it each way. You can modify it based on the termination or remarriage. You can modify it based on the cohabitation, the financially supportive relationship. It just depends on the facts and circumstances. Are they going to be engaged for 5 years, or are they going to be engaged for 2 months?
Right.
That's
trying
really
to speed up that wedding.
Yep, exactly.
Start sending them gifts now, maybe.
Yeah. Now I had a case where the lady got remarried and then just didn't tell the guy. And he eventually found out, and we had to go. She got remarried in a different state. I'll just say Georgia to make it easy, because I don't want to give identifying
Right. No, I
information.
got you. Yeah.
So then we had to go and track down and figure out what county in Georgia they got married in, and go to the records office there and pull the marriage certificate from there, because they would not tell him anything. They were denying that they were married. They denied that they even lived together.
Right.
And we eventually found it, got it terminated, and he was good to go. But
people
can be shady.
It was a nice try.
Yeah.
It was a good attempt.
I mean, when you're collecting a big check every month, I get it.
Right.
But, not legal, not ethical.
All right, let's get to Laura's question here. Laura says, how do I go about removing a small claims case filed in Sumter County from public record?
I don't know that there's really any way to remove a small claims case from public record. Once it's in the public record, it's in there. Now, of course, if it ever comes up, you can just explain it or provide the disposition, meaning how it ended up, whether it was dismissed or you won or whatever it may be. But typically, with criminal cases, you can seal them or expunge them if you've qualified, depending on the charge and things like that. With civil cases, they're there. There's no real way to kind of delete them, so to speak, that I'm aware of. Maybe in certain circumstances. I mean, I know there have been cases where, if there's media people involved or a high publicity case, they will seal the files, so they'll become confidential. You can still see that the case is there. You just can't see the underlying documents.
Gotcha.
So they do have some protection for things like that, and especially if there's sensitive information that can be redacted or sealed. But, just removing the case as a whole, I don't think there's any real way to do that. But also, that case really shouldn't cause you any harm down the road. I mean, if you're applying for a job or a loan or something, they may ask, have you ever been involved in a lawsuit? And you say, yes, this is what happened, this is the case number, so on and so forth, and that's about the end of it. That's just kind of part of life, and you got to disclose it and move on.
Okay. I'm just going to throw this one at you.
You always throw stuff at me.
Everybody no matter what field you're in, everybody always has the number one question that's asked them, right? So,
Yep.
So as a radio personality, I always get, what's the best way? What's the trick to winning the contest? How do I get those concert tickets? What's the question you get? What's the party question? You're there. What do people ask you the most? Or you're like, man, if I had $1 for every time I get asked this, because when they got you, it's like, I have Mo DeWitt right here. I've got him for 5 minutes. Let me bend his ear.
I mean, we get so many different questions, and they're all over the place. But I think the number one misconception, so to speak, is that, you can kind of buy your way to a victory, right? So people think, oh, I'll just throw some money at this, and you can take care of it, and we can just basically lie, cheat our way to the finish line, so to speak. In divorces, certainly the biggest complaint I get all the time is, why do I have to provide all this financial information? And it's, because that's what the statute says. That's what your legislators say you have to do.
Right.
You can argue with me all day long on it, but I didn't make the law.
Right,
I'm just here to tell you what it is. So you can follow it or you can not, and a judge will yell at you and sanction you for it. So
and then they walk away grumpy.
Yeah, I was at dinner. This was maybe a year or two ago. I was at dinner, and this client saw me there, and he stopped me and started talking to me, and he actually started complaining. I'm really upset with your office that I have to provide all this financial information, yada yada.
At dinner?
And, yeah, I mean, he's telling me this at dinner. I wasn't having dinner with him. I was just in the same restaurant.
Yeah.
And I go, I'm sorry, but that's just what the statute requires. And then a lot of times they'll try to say, like, let's say you have to provide your credit card statements, right? Well, they'll give us the first page of them. Well, no, we need all of them,
yeah.
right? And so a lot of times they're like, well, now I'm fighting my own lawyer. I'm fighting my own lawyer. Well, I'm telling you what you need to do.
Right.
You can hear it from me, or you can hear it from a judge when a judge now orders you to pay the other side's attorney's fees.
Mm-hmm.
So you can learn your lesson now for much less, or you can learn it later. But a lot of times people think that they can kind of trick the system. And look, with experience, there are things that come, that you can, I don't want to say manipulate, but there's definitely ways to gain certain advantages in certain areas and frame certain issues to be in your best interest. But, when it comes to disclosure, especially in a divorce, if you don't disclose things, that's how the case gets overturned. That's how you create a whole mess for yourself. It can really become a problem. So that's why you want to be upfront, and then we'll frame things in your best interest and make the arguments that we can.
Right.
But we can only argue the law. We can't change the facts. And I think that's where people get confused is they think that we can change the facts. I can only deal with what you come into my office with, whether it's an injury case, a criminal case, a family law case, whatever the facts are, the facts are. And let's go back to the Murdaugh case, right?
Mm-hmm.
He walked into their office. He told him one story that wasn't the facts. Facts came out based on the video that Alec Murdaugh was at the kennels and lied about it.
Right.
Now that defense attorney has a much harder job.
Wish we would have known that ahead of time.
Right.
That type of thing.
Well, yeah, because everything changes, right? Their entire story changed, and that didn't come out till right before the trial, too. So, they had filed a notice of alibi. That was out the window because the timeline changed. They clearly proved that his alibi was a lie.
Right.
And so when you're not honest with your attorney, when you're not disclosing the information to your attorney, and remember, you have attorney-client confidentiality.
Right, yeah.
So if there's something that's a problem there, you're better off bringing it up to the attorney so the attorney can figure out how to frame it and how to deal with it in your best interest. Here, had he disclosed to the attorneys up front that, hey, yeah, I was at the kennels, they may have been able to get ahead of that. It still would have been messy, certainly, but it looks a lot worse when you're filing a notice of alibi that clearly was a lie.
Mm-hmm.
The timeline that they framed their case around doesn't add up. Their defense completely changed. It makes things a lot harder when the attorney is surprised by something, especially right before trial.
Right.
Or even worse, in the middle of trial.
Wish I would have known.
Yeah. I mean, I had a case one time where we were putting on a certain type of defense, and part of that was the client's prior criminal record could come into play.
Mm-hmm.
And sat down with her. You've never been arrested, right? Besides this case, you've never been arrested. You have no criminal record, so on and so forth. Put her on the stand. Have you ever been arrested? Not as an adult.
The question was, have you ever been arrested?
Right. And so 3 hours of prep, you didn't tell us that you had a juvenile record, which again could come into play in this situation.
Right.
Which normally juvenile records are confidential, and there's a whole other issue. But that would have been nice to know prior to the trial in front of the jury.
Right.
Right. So, I guess back to your original question, what's the number one thing? It's not so much a question. I think it's that people think that lawyers can kind of change facts or trick people. It's, hey, we take the facts, we take the case, and we come up with the best arguments based on the law.
Right.
And that's
your
really
plan.
what our job is.
And it's good to know all the moving pieces before you go and you make that plan.
Exactly. When the plan changes in the middle of the trial, that's usually a bad thing.
All right, so let me ask you this. This might stem into this, and we only have like 2 minutes here left in this segment. But this person asked, I believe my husband, soon-to-be ex-husband, is hiding assets. Is there a way to find out about his assets prior to filing for divorce?
So there's a number of different things you can do there. You can run a credit report, see what what shows up. Basically, are there credit cards you didn't know about? Right. Are there things on the credit report you weren't aware of? Now you're also going to want to see where is he banking? Are there bank statements coming to the house? What financial institutions are they from? Because as part of the divorce, we can send subpoenas to those financial institutions for all bank accounts in his name or jointly in his name.
Okay.
So that's the first thing to look for. If he's opened up completely separate accounts, you're going to want to subpoena those banks, but you kind of have to know or have an idea what those banks might be.
Okay.
Now, the nice thing is, nowadays, unless you're dealing in cash, which so few people are, the money's traceable, right? So what it's got to come from your employer or however you get paid to one bank account, and you can kind of follow the money. And so if it's a really complicated case, maybe we have to bring in a forensic expert to follow that money, to follow that trail. But usually it can be found unless it's cash.
Some sort of trail everywhere.
Yeah, even with Bitcoin or crypto, there's still some sort of trail there.
Yeah, because you're getting a check from your corporation, your company, your business. Nobody's doing everything in cash.
One would hope. I mean, I had a client years ago who I think the IRS came in and seized like $300,000 from his safe in cash.
Wow.
This was before he came to us. So he was apparently dealing with everything in cash. He also literally had 100 credit cards.
Oh my gosh.
Because I had to do a spreadsheet of 100 credit cards.
Wow.
And the balances on them. So
that's just making me sweat thinking about that. That's crazy. Wow. All right. So we got more of your questions, more of your answers coming up here in just a couple minutes. Plus, your Mo Pro tip of the week is on the way as well. If you've got a question, send it in to us, ask@DeWittLaw.com. You can also go to DeWittLaw.com for all your information about the DeWitt Law Firm. You are listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm, answering your questions that you email to ask@DeWittLaw.com. You can also leave a voicemail, 407-53-MOSES. We'll play that voicemail on the air, and you'll get some advice from Mo. You can check him out, DeWittLaw.com, or you can also call the office anytime. Somebody will be there to point you in the right direction. 1-800-DeWitt-Law. That is 1-800-DeWitt-Law. All right, Mo, a couple more questions here if we can get to them. Can I file a lawsuit for discrimination on behalf of a deceased relative? I have notes written by the deceased with dates, documentation of instances and circumstances of unfairness and irregularities, unresolved complaints, and so on.
So an estate typically can bring a lawsuit. So you'd have to set up an estate for the deceased individual and then bring that lawsuit. But here it's really going to come down to the facts and whether you can prove this lawsuit without this person, or if you have enough evidence to prove it, and what would the damages be.
Okay. So
you have to look at those three factors. So obviously in something like a wrongful death lawsuit where the person is deceased and they died because of the wrongful conduct of another, that's an easier case to bring, right? Here, if you're claiming some sort of discrimination, well, typically with discrimination cases, the main witness is the plaintiff. So do you have someone else to witness this kind of conduct?
Gotcha.
And then, what are the damages here? Well, depending on the type of discrimination, there could be statutory or liquidated damages, meaning they're fixed by statute. You basically get some sort of fine, per instance, or something like that. Or they could be, monetary damages based on the damage that was caused to this individual. But how do you prove that without the individual?
Right, yeah.
Depending how they died, assuming it wasn't related to the discrimination, what are your damages there, right? So I would need to know a lot more to kind of dig into this case and answer this completely. But in short, yes, an estate can bring a lawsuit really for almost anything, as long as the estate has the ability to prove that lawsuit and prove damages in that lawsuit. But when you lose your main witness, sometimes that becomes very difficult to do.
Yeah, I would think so. Okay, good to know. All right, we got about 2 minutes. Let me try and get to this one real fast. Do I have any right to the marital house that was bought before marriage but refinanced several times during? The house was bought in 2004. I moved in 2005. We got married in 2015, have 3 children together living in the house. The last time the house was refinanced is 2020. My name is not on it. Do I have any rights? Can he throw me out?
So let's start with your rights. So it's still your residence. Just like, a tenant, you can't just be thrown out on the street, right? It's still your home. It's still your residence. Now, so no, he can't just boot you out even though his name is on the house. I mean, my name is the only one on my house. If I try to kick my wife out, she would.
Yeah, you're in trouble.
Yeah, I'm already in trouble, Jay, but I'd be in a lot more trouble. So no, they can't kick you out. Now, from a divorce perspective, the person whose name is not on the deed and the house was purchased pre-marital or prior to the marriage, they're still entitled to the passive appreciation of the home that occurred during the marriage.
Okay.
So, just to make easy numbers, if when you guys got married, the house was worth $100,000 and now it's worth $200,000, again, just passive appreciation, market's gone up, mortgage has gone down, you're entitled to half of $100,000 or $50,000.
Okay.
It's what we call the call formula, KAAA. It's a case out of the Florida Supreme Court. Basically talks about passive appreciation, and that's what you're entitled to as part of a divorce.
Okay.
Now, you say your house isn't on the deed here. If it was refinanced several times, you should go back and check that. Sometimes your name will be added to the deed as part of a refinance. And if it is, then the entire house becomes marital. So it can be a cautionary tale on one side. It can be a windfall on the other.
Gotcha.
But if you add your spouse to the deed of a home that was purchased prior to the marriage, the courts are going to look at that as a gift. They're going to look at that as you intended to add your spouse to it, and now it becomes 100% marital.
Okay. Very
few exceptions to that. There are some out there, but they're very few and they're difficult to prove. So if you're going to make that decision, know what you're getting into. And I think I've told this story before about the lawyer who got divorced, lost half his house. A few years later, saw his wife at a bar, fell back in love, or ex-wife at the time, got married again, said, hey, I love you so much, I'm going to put you back on the deed, divorced again. Now he's down to 25% of his house.
That's so crazy.
Paid her 75%.
Wow.
So, yeah, just know what you're doing, right?
Right.
Be informed, know what you're doing. That's what part of the show is all about. But yeah, can't kick you out, and you do have some rights to some increase in the equity. Of course, it depends what the numbers are, and you have to prove all that, but there are some rights there.
Perfect. Awesome. Great advice. All right. So send those questions in again for next week. ask@dewittlaw.com. Or if you have something that you want to ask, get some advice with, maybe off the air, you can call the office anytime, 1-800-DeWitt-LAW. You are listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.